How is a trustee removed? If you have questions about how the trustee of your family trust is acting, you may want to consider having them removed. However, removing a trustee can be a timely and costly process. Once appointed, trustees have numerous rights and responsibilities. However, they typically don't have the right to quit doing what they're supposed to without other people's approval. A trustee who fights against their removal can lead to a long, drawn-out court battle that sucks money directly from the trust. Therefore, the provisions for removing a trustee often hinge on the terms of the trust and the real-world limitations of whether you want to take the time and spend the money. Outside of the conditions set forth within the trust, it typically requires a court order to have a trustee removed. Who has the power to seek the removal of a trustee? Only specific individuals have the standing to remove a trustee. If a trust is revocable, the person who created it usually is the only person who can remove a trustee. This person, most commonly known as a grantor or trustor, can undo those appointments or even revoke the trust itself. Revocable living trusts are common estate planning instruments. Often the grantor will name themselves as a trustee while they're alive, and they'll have the capacity to manage the trust assets. However, once the grantor passes away, the trust is going to become irrevocable. For irrevocable trusts, the grantor, because they're deceased, obviously can't serve as the trustee. So in these cases, the circumstances for removing a trustee are going to be more limited than the rights that a grantor would have. In these instances, beneficiaries are commonly the ones who have the ability to have a trustee removed, either within the terms of the trust or by going to court. If the terms of the trust allow it, then the beneficiaries, usually who constitute a majority, are going to have the opportunity to remove a trustee. Sometimes it requires a supermajority vote. However, if the trust does not contain any provision for voting or removing a trustee, then the beneficiaries are going to have to go to probate court to have them removed. So unless you're a grantor, beneficiary, or co-trustee of the trust, you're typically not going to be considered an interested party, which means you're not going to be able to have a trustee removed. Under what circumstances can a trustee be removed? There are two typical situations where you're normally going to see a trustee being removed. The first is the death or incapacity of the trustee, and this is typically pretty straightforward, as you might suspect. However, if you want to remove a trustee because you believe they've broken their fiduciary duties, then you might need to fight this in court. A trustee is likely to be found to have violated his or her duties owed to the beneficiaries in a number of ways. One, by mismanaging trust property. Two, by charging illegal or excessive fees. Three, having conflicts of interest with trust assets or perhaps a beneficiary. Four, committing fraud. Five, ignoring the terms of the trust. Or six, being unresponsive or uncooperative, fighting with beneficiaries. Of course, it's highly unlikely that a trustee is going to concede that they breached any of these duties. How long does it take to remove a trustee? Removing a trustee for a breach of their duties can be a long and expensive process. The trustee has the right to hire their own counsel and most often is going to be able to use trust assets to pay for those attorneys to defend themselves against removal. Therefore, beneficiaries are often spending double to have a trustee removed. You're going to need to hire your own attorney and pay them to represent you. Meanwhile, the trustee is going to be able to pay for their own representation, but from trust assets. Sometimes beneficiaries can recover the expenses that they incurred removing a trustee, but those are very fact determinative and not necessarily always going to happen. Also, pace of litigation is difficult to estimate. It can take years, not including appeals, until a trustee is formally removed and potentially surcharged or forced to pay costs and fees and compensation. Even during this time, if they remain in place, the trustee still has to uphold their duties, even if they're being sued. So before starting any petition to remove a trustee, it's always best to consult with an experienced probate litigation attorney who's going to be able to tell you the pluses, minuses, likely costs, timeframes, etc. Have questions? Give us a call or shoot us an email anytime. At RMO, we protect people like you every day. Thanks for watching.